All righty. Well, good afternoon, everyone. Thank you for joining us for this quick hitting workshop on intellectual property considerations for SBIR and other federal funding programs. My name is Cameron Law. I serve as the Executive Director of the Carlson Center for Innovation and Entrepreneurship. And I'm excited to be joined by two of our partners here, one on campus. So we have Raphael, who leads the Office of Innovation and Technology Transfer here on campus at Sac State. And then we also have Benjamin, who's led our prior two workshops and leads advocacy chiefs. And we've partnered on this three-part series where we're bringing you some information on how best to access SBIR and STTR funding, but then also some of the ins and outs of one, protecting your IP, but also setting yourself up for success in that program. If you haven't attended the prior two sessions, we will follow up with a recording of those as well. So you haven't totally missed out on them. You can then plug into those workshops from there. But with that, I'm going to unshare my screen. And as I do so, Raphael, who will be leading the workshop today, will take over. But we're really excited to have you join us for this session and dive into how you can best protect yourself and understand what some of your considerations are in protecting your IP as you go through the SBIR program and other federal funding. So take it away, Raphael, and thank you all for being here.
Well, thank you, everybody, for being here. I just want to make sure, can you see the slides on the screen?
You got it.
Okay, good. How many of you have applied for an SBIR grant before? Nobody? Okay.
Ben has applied, he said.
Oh, Ben,
maybe on one hand, maybe only one hand, or maybe two. No, I'm just kidding.
Okay. All right. Okay. Well, today I'm gonna talk about IP consideration when you're applying for an SBIR grant or when you receive an SBIR grant. So I'm just gonna cover two areas, IP ownership and IP obligations that a small business will have to the U.S. government, and also IP considerations when you subcontract that work to a university. I previously served the University of Hawaii and UC Davis in a similar role that I'm serving Sac State. And they would have small businesses who had SBIR grants who would subcontract some of the work to a university. So I looked at one of the latest SBIR solicitations, this one NSF 24579 from the NSF. And if you click on it, you're all going to get copies of these slides. If you click on it, you can read the full solicitation. But I'm probably sure that if you attended the previous two sessions, that SBIR provides non-dilutive funding, and that it's for you to develop your technology, and even though it might be a high-risk technology. However, an SBIR awardee is subject to the Bayh-Dole Act, and I'm going to click onto question 75 in SBIR, STTR's frequently asked questions to go over what your obligations would be to the federal government and the Bayh-Dole regulations. So when you get SBIR funding, you have obligations to the federal government for any IP that you develop using SBIR funding, okay? And the federal government does have certain rights to any invention that you come up with, any subject invention that you come up with. So you're required to disclose all patent applications you submit, all inventions that you created as a direct support of NSF or SBIR support, okay? Usually you have 60 days to report it, and you go on their system. It's called iEdison, and it's not so hard registering for iEdison. I did it for Sac State. Sac State had never done it before. But it's a little bit complicated to use, but if you go to the guidelines for using this system, you can read how to use it. And actually, you can call someone from NIST or from the agencies that's providing the SBIR award, and they can walk you through it. That's what was done with me. Okay. So as I mentioned before, that you have obligations under the Bayh-Dole Act, okay? And they're not very onerous. So you have to report any invention that you develop under this funding, and that they use the term subject invention, which I'll cover later, because the federal government, particularly the agency that funded your research through the SBIR award, is entitled to a non-exclusive, non-transferable, irrevocable, paid-up license to practice or have practiced for, on behalf of the U.S., the subject invention throughout the world, okay? And that doesn't sound so bad. So basically, if you come up with an invention, the federal government could use it. The federal government isn't going to manufacture that invention. They're going to get a company to do it, and it probably will be your company. So you're still going to make money from it. So it's not as bad as it sounds. Also, the federal government has what's called marching rights on inventions created by federal funding, okay? And they only will do this in the case of a national emergency. Now, the Bayh-Dole Act has been around for 44 years now, and the federal government has never exercised marching rights. So the likelihood that this is going to happen is not very likely. So, as I mentioned before, we have obligations to the federal government, but who owns the invention that you come up with under SBIR funding? Well, your company does. They own it. And these are some definitions, and you could read through them later, but you can see the definition for subject invention: any invention that you conceive or first actually use to practice and the performance of the work under the funding agreement, okay? So this is not onerous at all. Oh, and but you do, under Bayh-Dole, you do have to file a patent application on the invention. So let's look at IP considerations when you subcontract work to a university. And I'm actually going to use a subcontract between a small business that receives a SBIR funding and the university, the Regents of the University of California. So let me share screen, switch screens real quick. Okay.
And as you, oh, there you go. Just quick note, if you do have questions, feel free to throw them in the chat. I'll help bring them in to Raphael if you have any questions as we go. So
yes, and let me know if there's a question in the chat, Cameron, please. That way,
you got it.
You know, I'm able to switch from looking at the slide deck to read the chat. Okay, so this is the template for the subaward used by the Regents of the University of California. It's very similar to what other California public universities might use if you want to contract some work to the university. It's not a very complicated agreement. It's only about 9 pages. And what I'm going to cover today are the terms here that pertain to intellectual property. And those are confidential information, ownership of inventions, licensing rights to university inventions, publications, and there should be a use of names clause, use of names and trademarks. Those are the things that apply to you with regards to intellectual property. Okay, did it switch back to the slide deck?
You got it.
Okay, just wanted to make sure, because on my screens, they don't always put a border on it. Okay, so these are terms from the agreement regarding confidential information. They only have a couple of terms, but the important thing to note is that it's very difficult for a public university, whether it's in California or a different state, to be able to maintain or guarantee the confidentiality of any confidential information that you provide to them. And this is even stated right there in the agreement. However, as stated in the agreement, if you provide any confidential information, reduce it to writing. Make sure it's in writing. If it's provided orally, then reduce it to writing within 30 days of that disclosure. Also, do not reveal any trade secrets. A trade secret is something you want to keep secret and confidential for a long, long time. So don't reveal any trade secrets that have to be kept confidential for more than 5 years. And they do have some exclusions as to what is considered confidential information and what's not. What's not considered confidential information is anything that was already known to the principal investigator who's doing the work for you, the research work for you, before he received it, okay? Also, anything that's legally disclosed to the principal investigator by a third party who has the legal right to make that disclosure. So basically, you can't say something is confidential information if it's already out there. And also anything that becomes known through no fault of the principal investigator. But mostly they will also add, most California public nonprofit institutions will also add a couple of additional terms, one of them being whatever the principal investigator develops independently on her own or his own. And they'll also add another term about if they're required to disclose certain information, then they have to disclose that information as required by law. And what they do is, if generally what the university will do, if there is a legal requirement to disclose what could be confidential information or a document containing confidential information, they generally will go back to you and ask you, can you tell us what is in here that you think should be redacted? What in here we should not disclose? And generally, they will redact that information. In other words, they'll color it in black to make sure it's not seen. With regards to ownership of invention, generally, even though you're paying a university to do research work for you, public universities will require in their contracts that they own any intellectual property that they develop. For example, if they develop an improvement to your invention, the university would own that improvement. However, that doesn't sound as scary as it may seem, because the university probably will not be able to license that invention to anyone, because that invention, that improvement, will be dominated by the patent rights to your original intellectual property. And they would have to go back to you to be able to practice that improvement. And secondly, the best entity to be able to commercialize that improvement is the small business that awarded the subcontract to the university. There may also be joint inventions. Now, with joint inventions, it's important to know that in accordance with patent law, someone who's a joint inventor can basically do anything with that joint invention. They can commercialize it, license it, possibly even sell it. No, they cannot sell it. No, they cannot sell it. They can license it, and they can create a company to commercialize that invention. But the one thing, they can even sub-license it to a company to create products, to manufacture and to sell. But what they cannot do, what a joint inventor cannot do, is exclusively license that invention. They cannot do that without the other inventors being involved. So if there's a joint invention between one of the individuals from the small business and the university, it's best that both the university and the small business work out some kind of an agreement together as to who's gonna be the lead in filing the patent, prosecuting the patent on that invention, and commercializing that invention. Generally, probably the small business should be the lead on commercializing that invention. But if you don't have a lot of money for your patent budget, you may want to let the university be the lead on prosecuting that patent. The university, of course, will be asking to be reimbursed for the cost of prosecuting that patent. But in that agreement, you can put something in there to delay reimbursing the university until your company is able to start commercializing that product and getting revenue. So it's a nice arrangement because some of these universities actually do make millions of dollars in licensing and royalty income, so they can afford to prosecute a patent and pay up all the expenses and later get reimbursed for those. So it's not a bad deal for the small business to be in a situation where they can have the university prosecute the patent, pay for all those costs, pay for the lawyers, and later on, when the small business starts selling products, and then they can reimburse the university for those patent prosecution costs, and then share in the royalty revenue. They can share some royalties with the university. But the university is not the best in terms of, it's not going to make products to sell. They would find a licensee to do that, but the small business is the best candidate to do that. Oh, so let's talk about inventorship. Inventorship is going to be determined by U.S. patent laws. And if the university comes up with an improvement to your technology, the university has to submit claim title to that invention by going on the IRS and claiming title to that invention. And again, the government would be entitled to a non-exclusive royalty-free license to that improvement, or if it's not an improvement to that invention, including a joint invention. But again, the small business is in the best position to commercialize any improvement to its technology, as well as any joint invention. Okay, licensing rights to university inventions. As I mentioned before, if the university comes up with an improvement or comes up with a totally different invention, they own that invention and they will try to license it. If it's an improvement, it's going to be very difficult for the university to license it to someone other than to the small business. If it's not related to the technology, it might not be difficult licensing it to another party, but the university generally will always offer the small business a first right to negotiate a license or an option to that technology. Generally, they will, with the University of California, they'll give you 60 days to let them know if you want to negotiate a license, and an additional 90 days, so that's 5 months, that you have to decide whether you want a license and to negotiate it, okay? And as I mentioned before, you know, they require the small business to pay for patent costs, but you can negotiate that, so the university will pay for that, the patent costs, and you can reimburse them later. And another thing you find in the clause for subawards is that nothing in that sub-agreement, that subaward, in which you subcontract work to the university, nothing in there gives the university a right to your intellectual property, okay? And nothing in there gives your company the right to the university's intellectual property with IP that hasn't been developed or IP that's already developed. But again, even if they come up with an improvement to your technology, they can't commercialize it without getting permission from you, because the improvement is dominated by the patent rights to your original technology. Publications, universities have the right to publish and disclose the research that they do. However, there will be a clause in these subawards in which the university has to give you a copy of any publication that they're going to submit. They have to give it to you 30 days before they submit it. And if there's anything patentable, and if your company thinks there's anything patentable in that publication, they can delay the publication for up to 90 days, which is plenty of time to permit for the filing of a patent application. Now, in the University of California's clause, it says, and if university concurs, publication disclosure will be withheld for a period not to exceed 90 days, et cetera, et cetera. You know, you can negotiate the underlying words out. So if the small business says patentable subject matter, delay it for 90 days, then both the university and the small business can work out the filing of a patent application. If you don't negotiate these words out, if you think there's patentable subject matter in that publication and the university says no, then basically you don't get that extra 90 days. And finally, let's talk about the use of names, okay? You don't want, and the university's not going to do this anyway, but you don't want the university using your company's name for advertisements, for press releases, or publicity, okay? So, and vice versa. So do I have any questions out there? Oh, there's something.
Yeah, we just got one in the chat. How negotiable are these agreements?
Well, they are very negotiable. Okay, the things that are not negotiable are the things that the university is required to do by law. Okay, the things that are not negotiable is that we don't want the government to have a non-exclusive royalty-free license. That's non-negotiable. That's a federal law. So things like that are obviously non-negotiable. Things that are illegal are not negotiable. But things like the time you have to negotiate a license, the time you have to decide on an option, those are negotiable. And when you're talking later about a license, of course, royalty rates are negotiable. You can negotiate whether you want to pay patent costs now or later, those things are negotiable. And a reasonable person on the university side is willing to negotiate.
Very good. That's the only question in the chat, so I'll maybe prompt. Oh, there's another one here. Go ahead, Vin.
Are there other alternate structures for these university insurance? Can small business use university research facilities independently? Okay, I want to make sure I'm understanding that right. Are you saying, can you come to the university and use university's research facilities? Is that what you mean? I don't hear a response.
We can't hear you, Benjamin.
Okay, I'm going to assume that's what they mean. But some universities will allow a small business or even a not so small business to come and use their facilities, but they'll require things like reimbursement for using their facilities and equipment, and they will probably also require liability protection and indemnification, things like that. You can't just come and use the facilities unless you happen to be a student and say a program that your small business is in, and you're, let's say, working on your master's. That's one of the work for, that's your master's thesis is based on that work. Then as a student, you can use the university facility, and some of you may be in that position where you're actually students here at Tax State.
There was another question in the chat. Do you want me to read it, or do you got it?
I'm going down. What if the technology is originally a licensed product owned by the university, and the company is seeking to make an improvement to that product? Okay. That is a very good question. And if you want to improve that product, then the university has already licensed the original product to a company, the university will probably contact that company and make sure that there's no issues with them doing a subaward to make an improvement to that product. And it all depends on what may be in the licensing agreement between the university and the company. Would you, Lynette, that would be the basis of an SC chart process, which is the cousin. I'm not sure. Oh, that's not a question. Okay. Yeah, any other questions? Well, if later on you do have any other questions, please feel free to send me an email. The last slide has my contact information on it.
Very good. Awesome. All right. Well, it looks like there's no additional questions. Ben, I don't know if you had any additional thoughts you wanted to share before I do a final wrap or anything. We're not able to hear you, sadly. So no worries. Well, I think Raphael, any last thoughts from you before I close us out?
No, I just want to thank everyone for coming. And again, you have any questions, feel free to reach out to me.
Awesome. All righty. Well, thank you all for joining us for this session. We will be following up with the recording as well as the slides. I will also share the recordings of the first two sessions that Ben has led. And in the chat, you can see an opportunity to connect with Ben in relation to kind of learning more about the SBIR STTR program that he's doing with the city of Sacramento. And yeah, we look forward to seeing you take advantage of the opportunity and apply for one of the cohorts that he will be running. So in the meantime, keep an eye out in your email for the follow-up. But thanks for being here, and thank you all for the time. So we'll see you next time.
Thank you.
Cheers. Thank you all.
Thank you.
All righty. Bye.